Hello everyone, welcome back. Happy Saturday. So in this video, I'm going to talk to you about the Marchman Act and specifically the 2024 changes to the statute. Now, I'll tell you, this is what I'm looking at. This is the laws of Florida. It is sort of the old statute with the changes that have been made. We've been going through this thing all morning. The actual brand new statute, for whatever reason, the state of Florida hasn't even decided to publish yet, so it's a little frustrating. I've also spoken to some friends in various counties, and it seems like everybody's struggling to get up to speed with this thing, and we're now, 2 weeks into July, and, the new law kicked in on July the 1st. So here's the big change, okay? This is the most important thing, I think the thing that we're going to grapple with initially. So you remember, for the longest time, Marchman has been a two-step process. First being a period of assessment and stabilization, and the second being the treatment services portion, where we send the person to treatment. And, you had to have an assessment done first, and that was either done on an emergency basis without a hearing, or a non-emergency basis with a hearing. Then you had to file a petition for treatment services and get a hearing, and so there were these two steps. The big change is that it's no longer two steps, it is one step. And so let me do the best I can to muddle through this. So basically what's going to happen is you're going to file, and by the way, the statute numbers have all changed too, which isn't helping things. You're going to file a petition for involuntary services. One petition, only one. And further into the statute, and I'm going to read this for you because it's just the easiest way to do it. It says, when the petitioner asserts that emergency circumstances exist, or upon the review of the petition, the court determines that an emergency exists, the court may rely solely on the contents of the petition and, without the appointment of an attorney, enter an ex parte order for the respondent's involuntary assessment and stabilization, which must be executed during the period when the hearing on the petition for treatment is pending. So what does that mean? It means that rather than filing two petitions like I have before, I'm going to file one petition, a petition for involuntary services, but in that, I'm also going to make a request for that order for assessment on an emergency ex parte basis, requesting law enforcement to go pick the person up and take them to be assessed. And I'll talk about the assessment in a separate video because that has also changed. And so this morning I created a brand new petition. So we don't use the court's pleadings. We have our own pleadings, unique to us, created by us, handwritten by us. Okay, so this morning I spent at least an hour going back into our system, creating a brand new petition that makes the requests for the relief that we think is going to be needed in these new cases. So I wanted to share that with you. I am sure as we get into this, as we deal with the different courts, the different counties, the different judges, the different general magistrates, that there will be more things that I'm going to report to you. This is really a work in progress, and it's really a matter of the lawyers figuring it out and the courts and the clerks all figuring this out, because it's just a brand new law and it's really made a big change. So I wanted to share that with you. I don't know how it's going to affect you if you're doing your own Marchman Act, and I've said in previous videos you can do it yourself, but I think it's a fool's paradise, quite frankly. But in any event, this is the big change. I appreciate you tuning in, and I will share more about the new Marchman Act in further videos. Take care. Bye-bye.